All right, great. I will share the other recordings once they are uploaded, but they were recorded, so for transparency and for your studies, I will share. Also, long I will rather share later the day. So perhaps our topic of discussion today is uh, we have extradition, we have rendition. They more or less go hand in hand, but they're mutually inclusive in as much as they're mutually exclusive. The other issues about the taxes. Uh, I said I'll focus just briefly on the overview and introduction to tax and the legal framework of taxes. And my point of focus mostly will be on income tax and stamp duty tax, the capital gains tax. So I don't know how far you guys are with your studies or rather with your revision. I know you have exactly 17 days to go. Actually, 14 days, 2 weeks, a fortnight from now to face the wrath of the CL exams. But I think by now you are adequately prepared. Or what you're trying to do here at the moment is to just overflow your cups, so you don't more or less go into the exam without something to rely on. So we've done this, and we could be, my team and I could be mentally engaged for because of this, but it's the path we chose to try and do something for all of you, so that it ends up being more or less I really want to call it hereditary, but I will call it it becomes generational. So next time you're on this other side of the screen. So I will start with the extradition for now, and then go into rendition, and then finish up with taxes. Okay. Well, before I begin on what extradition is, perhaps I would by now you should know the locus classicus of extradition, and thus the recent case of Chris Okemo. See, there was a tug and war contest between the DPP and the Honorable Attorney General on who exactly is supposed to be conferred with the powers to extradite, persons who've committed, I will call it an oh, sorry, I have intermittent Wi-Fi. I don't understand why, but we will just proceed. Well, I was saying that by now you should be knowing the locus classicus of extradition, and I've talked about the Chris Okemo case. So right now it's clear. So the DPP is the person or is the office charged with the mandate to extradite, persons to a foreign jurisdiction to face, trial. So you've come across Merriam-Webster. Merriam-Webster was its called, and most think in our legal profession we do use the dictionary by Merriam-Webster together with the Black's Law Dictionary to try and at least get the meaning of terms. So or rather Merriam-Webster's defines extradition to mean the surrender of an alleged criminal, usually under provisions of a treaty or a statute, by one authority, and this authority could be a state, right, to another authority, again another state having jurisdiction to try the charge. The Black's Law Dictionary, which is widely used by we lawyers, define extradition to mean the surrender of a criminal by a foreign state to which he or she more or less has fled for refuge from prosecution to the state within whose jurisdiction the crime was committed, upon the demand of the latter state, right? In order that he or she may be dealt with according to its laws, right? So it may be accorded as a mere matter of comity. I don't know if you guys were taught the principle of comity in your public international law. So it has to be in accordance with our principle of the doctrine of comity, right? Or may take place under treaty stipulations between the two nations. And you do understand that Kenya has ratified a number of treaties, and the first three articles of our constitution talks about treaties ratified by Kenya shall form part of the laws of the country. So if the treaties that have been ratified by Kenya and the requesting state, right, in this case could be another jurisdiction requesting for the repatriation of or the extradition of that particular alleged criminal, well, that's what we call the principle of comity. So this may be famed premised on, could be uh, the treaties, right, and even conventions. Okay, so like I said, it may be accorded as a mere matter of comity, or may actually take place under treaty stipulations between the two nations. So moving swiftly, extradition is more or less a formal request from an aggrieved state. Aggrieved state is now the requesting state, okay, or country, so as more or less to seek justice, since it is actually against international law for such a state to personally arrest a criminal due to the principle of sovereignty, which gives every state legal authority over the people within its borders. So when it is compelled by law, it is actually known as rendition. So you can see that I'm talking about rendition and extradition in one way or another. I'm just trying to juggle the two. So what you have to note, if this is compelled by law, that's when it is called rendition, okay? So rendition, in other words, is now the surrender or handing over of persons or property, particularly from one jurisdiction to another. So in as much as we have extradition as the umbrella body, we have rendition forming part of its branches, or perhaps one of its uh, main branch of extradition, because it is compelled by law, okay? Well, a state can exercise, you have Kenya can exercise its jurisdiction to try a matter given, that it has met any or maybe a number of conditions. So these conditions are actually four. One, you have what we call the active personality. Two, we have the passive personality. Three, we have the universal jurisdiction. And lastly, we have the territory. So this is where a state like Kenya can exercise its jurisdiction to try a matter, given that it has actually met those four conditions that I've mentioned: the territory, the active and passive personalities, and you have the universal jurisdiction. So extradition can be barred on the following grounds. One, its own citizens. Two, there is jurisdiction. Three, you have the possibility of certain forms of punishment. For example, you have the death penalty, or you have torture, you have inhuman or degrading treatment, or even punishment. And then you also have the political nature of the alleged crime. You also have the failure to fulfill the dual criminality. And then lastly, we have what we call the aut dedere aut judicare. This is a principle in Latin that is normally applied when it comes to 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 the barring, of of matters concerning extradition. So those things that I mentioned, these are uh, things that where extradition rather could be banned. So I've talked about failure to fulfill the dual criminality. I've talked about the political nature of the alleged crime. I've talked about the possibility of certain forms of punishment, that is, to mean death penalty or torture, inhuman or degrading treatment. or punishment. And then you also have jurisdiction, and then you also have the aspect of its own citizens. And then the last but not least, the Latin term of the art didere or judicare. Okay, so moving on to this, you have laws governing extradition, because in an exam setup, the one thing that you need to note is what are the laws that govern any area or principle or theoretical principle you have been taught in class for the past 1 year. So this is why you premise and found your own arguments. So if you list a number of laws, the case laws and conventions or treaties or lack thereof, then it gives the examiner, the aperture to know that at least you do understand the angle upon which this particular question is set, okay? So you're just laying the ground framework. So we have a number of laws governing extradition. And we will begin with our Katiba, as the Constitution of Kenya 2010. You have the Universal Declaration on Human Rights. You have the extradition. You have the Contiguous and Foreign Countries Act Cap 77 of our laws. This was a 1966 laws. Then you also have the extradition, the Commonwealth Countries, Act Cap 76 of our laws. You have the Fugitive Offenders Pursuit Act. This is Cap 87 of our laws. It was a 1936 law. Then you have the various treaties. For example, you have the East African Community Treaty of 1999. And then you have the Office of the Director of Public Prosecution Act of 2013. You have the Criminal Procedure Act. And then lastly, you have the Penal Code. So extradition involves a number of things. One, we have what we call the consular notification. So in a consular notification, in accordance with the Vienna Convention on Consular Relations of 1963, again, this was studied there in the Public International Law back in campus. So in accordance with the Vienna Convention on Consular on Consular Relations, rather, of 1963, says that any foreign national, who is a victim of a crime or a suspect of the same is apprehended by local enforcement agencies. The agency rather must notify the foreign embassy or consulate without delay. So the arrested or detained foreign national actually must be asked whether they will want their consulate notified. And then if he or she accepts, then notification follows. If not, the consulate will not be informed, subject to special bilateral agreements between the two states involved in providing for what we call a mandatory notification. So the agencies now are asked to, to ask rather, notify and even allow access. So that's what we call the consular notification. But then I will give you a case. It was an ICJ case of 2003 between Mexico versus USA. So here, the court held that the United States begin the process of review and reconsideration for all convictions and sentencing of Mexican nationals who the consulate was not actually informed about. So consular notification when it comes to extradition is very, very, very welcome to any proceeding concerning extradition. Okay. The other thing about extradition after consular notification and transfer or transfer after conviction. Okay. So upon an extradition request from a requesting state is the aggrieved state. So upon an extradition request from a requesting state is approved by the requested now. Can you hear me? Can you hear me? I'm
Yes.
having intermittent Wi-Fi connection. I don't understand. I'll have to revert to hotspot. I hope I'm clear now. Can you hear me?
Yes.
Awesome. Well, I was thinking about the detention in transfer or transfer after conviction. So upon an extradition request, from a requesting state is approved by the requested state, the latter now, the requested state will temporarily hold the fugitive before he or she is transferred to the authority of the former, for trial and actually in certain circumstances or instances, imprisonment. Okay. So moreover, once the requesting state has tried and convicted the fugitive, he or she could be surrendered back to the country of his or her origin to serve the sentence there. Okay. So, for example, the Chris Okemo's case, if they're tried on the other jurisdiction, I think it's the UK, the US, thereabout, they could be tried but serve the sentence here at home. Okay. So there is the case of Republic versus Wilfred Onyango Nganyi. This was ended up. This was a 2008 case that laid the ground framework for the detention and transfer after conviction when it comes to extradition. You should know that case. I've said it's R versus Wilfred Onyango Nganyi and another 2008 case. So, what are now the other processes of transfer of suspects when it comes to extradition? Well, there's something called extraordinary rendition. So, extraordinary rendition refers to the government-sponsored extrajudicial procedure in which criminal suspects are sent to other countries for imprisonment and interrogation, with a view or with an aim of extracting information. So unlike extradition, which is requested on the basis of an existing agreement or enabling law, extraordinary rendition or illegal extradition occurs in cases of lack of offense, being covered in treaty or refuge state is unable or even unwilling to prosecute. So we have the extraordinary rendition. So this is also called illegal extradition. I hope you don't get mixed up during the exams. Skilly sometimes use the synonyms of a word to just try and distort your thought process. So extraordinary rendition means illegal extradition. Then it of offense, being covered in treaty or even the refuge state doesn't have the power, to prosecute. So this process is actually, regarded as a violation of Article 3 of the United Nations Conventions Against Torture, UNCAT. And I know for those who did international human rights law in campus and public, you just because suspects are taken, to countries where torture during interrogation is common. Okay, so this was the case as well with regard to the Bakhtish Akasha, the Akasha brothers. I know you've come across this case. So there was Bakhtash Akasha, there was Ibrahim Akasha, and two others. It was quite a very emotive and intense, case that involves senior judicial officers. I really want to mention names. Well, the other thing is about irregular rendition. So there's illegal rendition, and now this is irregular rendition. So here, it is it is similar. Irregular rendition is similar to both extradition and extraordinary rendition. But it entails, kidnapping or deceit, so as to lure the suspect and return him or her to the aggrieved states or the requesting state's jurisdiction. And then we have deportation. What is deportation? So here, it is the expulsion now of a foreign national under immigration laws of a country. So it is the unilateral by a government to expel an foreign national due to illegal entry or conduct, or rather conduct dangerous, or conducted or deemed dangerous to the public. So now, unlike the other processes, deportation is more or less a civil procedure matter. The presence of the individual is normally deemed more or less inconsistent with the public welfare. And you can check the case of Sheila Amalemba versus the AG. So that more or less discussed the issue of the inconsistency and why should we deem deportation as a civil, matter and not a criminal matter. So the case is Sheila Amalemba versus the AG. So it is the issue of public welfare, the inconsistency when it comes to the public welfare. So the case is Sheila Amalemba versus AG. The other thing is about expulsion. What is expulsion? I'm not talking about the expulsion you had in high school for those who did. I'm talking about expulsion in the context of extradition. Expulsion, it is putting or driving it is the process, in which a refugee or an individual is ordered to leave the territory of a particular country. So it may be ordered by a court of law or even an administrative authorities charged with immigration duties. So this was the case, when Kenya wanted to close the Dadaab refugee camp. I hope you can remember. It brought a lot of tension within the country, the consulates, diplomatic relationships between Kenya and Somalia, until the extent even our own, minister or the cabinet secretary for uh, coordination of national government and internal security, Dr. Fred Matiang'i, ordered the closure. So it had to more or less attract the attention of the international community to persuade the country to just keep up with the refugees that are. So I think the matter is now settled. A grace period was given. The other is and penal servitude. What is transportation and penal servitude? So this is where it is with reference to the banishment of the Victorian age. For those who love history, you will understand what I mean by the Victorian age. So it is the forced exile now of a national as a form of punishment rather than execution, and considered an alternative of the same. Okay, so even though it is not used, it still remains in force in certain states or countries. For example, in the case of Hamim versus Mississippi, Hamim is it's actually Ham versus Mississippi. In this case, the court referred to it as an outdated, or outmoded punishment, but still held, on the limited circumstances it may be used. So even though transportation and penal servitude has become more or less stale when it comes to one of the options or alternatives of rendition, it is still being used. Okay. So what is the procedure for extradition? Okay. So I'll give you a case scenario that we were given as well. You have a Ugandan resident, let's call him Peter. So Peter is a Ugandan resident in Rwanda, right? So he was more or less driving, a lorry, full of logs. So he had just Kenya from Uganda, and in total disregard to the speed limit. Okay, so he was driving at 50 kilometers per hour, and the speed limit was 40 kilometers per hour. So thereby failing to notice the road bumps that were actually ahead. So Peter, who is a Ugandan resident, rammed into the first vehicle and swerved, to avoid the next one. So as a result, he hit a female pedestrian, who actually died on the spot. So upon now sensing danger, off from the scene of crime, where he hit that particular female pedestrian, and made his way back to Rwanda. So that's basically more or less what CLE may come up with. Such a case scenario, it's not hard to comprehend, but you will find students overthinking, and end up failing the exam, not because they don't know, but because they panic. So this is basically what CLE may bring, because it covers all the aspects and spheres of extradition. Right. On the flip side, so the DPP, continuing perhaps with my story, the DPP in Kenya, Nudin Haji, has directed that you, perhaps as a legal intern or as a pupil, at Rogati Road is where the headquarters of the DPP is actually situated. So you are the pupil at Rogati Road, the DPP office. So the DPP, Nordin Haji, has asked or directed that you commence the research or an opinion on how to complete the process of getting Peter back to stand trial in Kenya. And you are asked, set out the procedure that you will follow. 10 marks. Okay, so you're there, you're swatting, you're panicking. Well, it's noble, but don't be, because the moment you understand the concept, none of these units you should be cramming. I mean, you just have to understand. So you're there as a pupil, and you're asked to draft an opinion of the same 10 marks, or even 20 marks. You never know. Okay, because you could be asked to draft now what pleadings you filed for a court. Okay, so now away from a story, our Katiba under Article 2, Sub-Article 6, provides for any treaty that is ratified by Kenya, shall form part of the laws of Kenya under that particular constitution. And I think I told this before in the opening statement. So, however, or moreover, Article 157 of our Katiba establishes the office of the DPP, and it gives it authority to institute criminal proceedings and direct the IG of the National Police Service to investigate any information or allegation of criminal conduct without needing consent of any person or authority for commencement. Okay? When you look at the East African Community Treaty, which Kenya is a signatory under Article 124, Sub-Article 5, okay, of that treaty, it provides that the partner states, agree to enhance cooperation in the handling of cross-border crime, provision of mutual assistance in criminal matters, including the arrest and repatriation of fugitive offenders, and the exchange of information on national mechanisms for combating the criminal activities. If you haven't realized, I am answering that particular, case question that I gave you. Section 4 of Cap 77 of the Extradition Commonwealth Act, describes extradition offense if, one, it is an offense against the law of a requesting country, which, however, describing that particular law falls within the ambits of any of the descriptions contained in the schedule to this particular act. and is punishable under that law with imprisonment for a term of 12 months or any greater punishment. Okay, and still under Section 4, the act of omission constituting the offense or the equivalent act of omission will constitute an offense against the laws of Kenya if it took place within Kenya, or in the case of an extraterritorial offense in corresponding circumstances outside the country, that is outside Kenya. Okay. So the Office of the DPP Act 2013, Section 27(1) says a public officer, state officer, or even a state organ shall cooperate with the Director of Public Prosecutions, Nudin Haji, in the exercise of his powers and discharge of functions under the Katiba. So this act or any other written law and shall in particular do a number of things. 1, respond to any inquiry by the DPP. 2, comply with the lawful directions of the DPP. And 3, furnish the DPP with such information as the director may require to discharge his or her functions under the Katiba, that particular act, the ODPP Act itself, or any other written law. All right, so back to my question. Peter's actions of not adhering to the speed limit, resulting in the damage of personal property and death of a civilian, amounted to a criminal offense in both Kenyan and Rwandan jurisdiction, laws. Okay, so back to my CAP 77. Peter fleeing the scene and further fleeing the country actually made him a fugitive under the law. So Section 5 of the CAP 77 provides that every fugitive is liable, subject to this particular act and to any limitations, exceptions, conditions, or modifications to which the application itself of this particular act in relation to their requesting country is subject to be arrested, detained, and surrendered in the manner provided by this act, and is so liable, whether the offense in respect of which the surrender is sought is alleged to have been committed or was committed before or after the commencement of this act, which is CAP 77, or the application of the particular act itself to the requesting country. So the first step when it comes to the procedure is about building your case. Okay, so here, all requests for extradition shall be submitted through the diplomatic channel. So thus, the Cabinet Secretary in charge of the Ministry of Foreign Affairs has to be informed in writing of the same. This is followed by liaising through a directive by the DPP with the National Police Service to begin investigations on the incident that happened. So after investigations are done, the next action will be in and seek an arrest warrant to be issued for the fugitive. The first step is a diplomatic representative or consular office from Kenya, which is the requesting state, will make a request in writing for the surrender of the fugitive through a letter of request to the Rwandan Attorney General, or even the DPP. I think theirs is still the AG. Ours is different. The second step, the first step I've told you is about building your case. Second step is about sending a provisional arrest request. And I'm telling you, this is a question that could easily attract 20 marks, and it comes with procedure. So if you understand this procedure quite well, you're good to go. First step, I've talked about building a case, or building of that particular case. 2, I'll talk about the sending of provisional arrest request. So here, due to the urgency of the situation as the requesting state, we would request as Kenya a provisional arrest of the person sought pending presentation of the request for extradition. So the application shall be transmitted by means of diplomatic channel, that is to mean through the Ministry of Foreign Affairs. So the application for provisional arrest shall contain a number of things. One, you have a description of the person sought, that particular fugitive. Two, person sought, if that particular location is known. Three, you have a brief statement of the facts of the case, including, or if possible, you have the date and location where the offense or offenses was committed or were committed. Four, you have a description of the laws violated. Five, you have a statement of the existence of a warrant or order of arrest or a finding of guilt or judgment of conviction against the person sought. And you have a statement that the supporting documents for the person sought will follow within the time specified in this treaty. And that treaty is the East African, Community Treaty. Okay. Documents that the application for provisional arrest should contain, or rather the information. The third, sending of extradition request. So how do you do this? In sending of the extradition request, the request for extradition shall be sent, supported by either subject to bilateral treaty between Kenya and Rwanda, Article 6.2, okay, of that particular treaty. So you have accurate description, as accurate a description as possible of the person sought, together with any other information that will actually help to establish the identity and the probable location. Two, you have a statement of the facts of the offenses. Three, you have the relevant text of the laws, describing the essential elements of the offense for which extradition is actually requested. Then you also have the relevant text of the laws prescribing the punishment for the offense for which the extradition is requested. And you also have, last but not least, documents, statements, or even other types of information specified, in a paragraph 3 and 4 of Article 6.2 of the East African Community Treaty, as applicable on a need-to-need, on a case-to-case basis. Article 6.3 talks about, in addition to the requirements now in paragraph 2 of the same article, a request for extradition of a person who is sought for prosecution shall be supported by, you have one, a copy of the warrant or order of arrest issued by a judge or other competent authority. Two, you have a copy of the charging document, if any. And three, you have, for request now to aid the party, such information as will provide a reasonable basis to believe that the person sought committed the offense for which extradition is requested. So what you have to note, ladies and gentlemen, is all the documents in the request, you would be required to be authenticated. So this will be done via authentication by a notary public, or they purport to be signed by a judge or a magistrate or officer of the Kenyan government, and they purport to be certified by either being sealed with the official seal of the Ministry of Foreign Affairs, and then basically certified or authenticated in any other manner acceptable under the law in the requesting and requested states. So all while not providing any additional information required from requested states. Okay. So you have requesting state and requested state. Don't confuse the two. The fourth step is about surrender. So here, on granting now of the request, the requested state will surrender the fugitive for the purpose of prosecution in the requesting state, and the requesting state shall bear the cost of transit. So if Peter were to be brought back to Kenya to face charges, it is Kenya that is supposed to bear the cost of transporting Peter, or the cost of transit, from wherever Peter went to, that is Rwanda, back to Kenya. So if the fugitive now is a national of the requested state, the state could decide to carry out the trial process themselves without having to more or less surrender him to the jurisdiction of the requesting state's courts. Like I told you, there are things that will bar extradition, and one of them is the fact that the fugitive is a citizen of the requested state. So the requested state will find it fit to just try and charge the fugitive in their own country and not repatriate them, to Kenya or any other nation. So I've said if the fugitive is a national of the requested state, the state could decide to carry out the trial process themselves, without having to surrender him to the jurisdiction of the requesting state's courts. So once the fugitive is in custody, he will have the right of the Ugandan embassy being informed of his arrest. So this right can also more or less be waived by the fugitive, subject to existing agreements between Kenya and Museveni's land, that is Uganda. So ladies and gentlemen, that marks the end of what I was talk about when it comes to extradition and rendition. Like I said, there is a possible 20 marks question. You never know. You never know. So you have to prepare yourself in all aspects. And yeah, so perhaps just to try and more or less do a recap quickly on extradition, perhaps for those who missed what I was saying before. I said you have to know what extradition means. You have other forms of surrender of criminal suspects, fugitive and aliens. You have to know the basis of extradition. You have to know the principles of extradition. You have to know and understand the sources of the law on extradition in Kenya. You have to know the extradition under the Extradition Contiguous in Foreign Countries Act, Cap 76 of the laws of Kenya. Okay. You have to know, I'd say, the basis, basically, what it does encompass. So that's it. I'm done with extradition. So I would give you just 4 minutes of break, and then we start with taxes at 11:30 a.m. Right, see you then. So welcome back. So we'll do taxes for now. So like I said, it's the overview and brief introduction to taxes and the legal framework for taxes, and then focus on the income tax, stamp duty tax, and capital gains tax. So moving swiftly, you have, when it comes to taxes, you have a number of things that you should understand. What is the government source of revenue for some taxes, or the taxes, or taxes are general? You tax systems. You also have, how do we group, categorize, and classify taxes? Okay. So the sources of government revenue, I know this is not news, to you. So where does the government derive its own the revenue? So we have funds, you have fees and prices, you have state property, you have borrowings or loans, you have levies and charges, you have taxes, and that will form the basis of our discussion today. So taxes is the aspect of compulsory contribution from a taxpayer. Now, this is just basically the definition of taxes. It's it's compulsory or mandatory contribution from a taxpayer to the government to defray the expenses, that are incurred in the common interest of all, without reference to special benefits, that have been imposed or conferred upon that particular party or the taxpayer. So taxes, could be income tax, could be stamp duty tax, could be capital gains tax, could be excise duty tax, could be withholding tax as one of the forms of income tax. You have VAT in water view, the refundability of the same when it comes to VAT. And then we have fees. What is fees as one of the government sources of revenue? Well, fees is just an amount, which is received for any direct services that has been given or rendered by the government. For example, you have the airport departure, the parking fees here, in the CBD. You have the garbage collection fee. You have the driving license fee. Any fee that, more or less operationalizes the functions of the government will be rendered or considered as a source of revenue. And then we have prices. These are actually amount, which are normally which the government always receives for commercial purposes. For example, you have SGR, fare, or you have the when you go to GPO, those postal stamps over there. You have the revenue stamps. So those are some of the prices. Allow me to admit this person who is at the lobby before we proceed. Right, great. We move. Okay. So I've also talked about levies, and then we have borrowing. Borrowing could be internal and it could be external. Okay. So by external, we have bodies, that do regulate the borrowing cap. Right now, when you more or less look at the the PFM Act, the PFM Act has set a cap of, I think, 7 trillion Kenya shillings as the debt ceiling of our country. So the CS for Treasury at the moment, Ambassador Ukuri Yatani, wants more or less an amendment of that PFM Act so that the borrowing or the debt ceiling could be pushed to 9 trillion, right? While with the geopolitical wars between Russia and Ukraine, you never know what's coming, but it will really affect inflation, because right now with the sanctions, especially on crude oil, that the United States of America's President Joe Biden has imposed upon Russia. So that will mean if you are sanctioning Russia's oil, then the prices will definitely soar, because Russia is one of the OPEC countries. OPEC are countries, OPEC countries are those countries that are oil producers, large quantity oil producers. So Russia has the oil, has the natural gas. So if we impose sanction on Russia's oil, and Russia supplies most parts, even Russia did supply the US, with their oil. So when you are sanctioning that, it means it's gonna bang. So right now, I think crude oil retails at $130 the last time it checked. That was, I think, 2 days ago. So what that will mean for Mama Mboga who wants to pay, fees for licenses to carry out her business in town, a lot, because at the end of the day, oil and the US dollar had always measured as more or less commodity of sale. Okay, it affects everything. So we have not the World Bank on our side. We have the IMF. The World Bank and IMF also regulate our borrowing. Okay, the other day they did raise a red flag when it comes to our borrowing. So one of their proposals was to perhaps try and merge Kenyan universities so that we could more or less save on cost. Well, how practical that is, I don't know, but time will tell. So IMF and World Bank regulate our external borrowing. Okay, so they are international financial institutions. So you can also find that in as much as we may not borrow from World Bank and IMF, we can also borrow from other foreign governments or countries, right? So that is about external borrowing. We have internal borrowing. So for internal borrowing, the government usually raises in revenue through the issue of treasury bills and the treasury bonds in the local market. Well, another issue of sources of government revenue is about the state property. So here, the income that more or less arises from government property such as land, forest, the mines, when you go to Nairobi National Parks, those fees you pay, all these things, it's also another source of public revenue. So the income will arise from payment of rents, royalties. Okay. Their source is about fines and penalties. So here, if individuals and firms do not actually, or they're disobedient to the laws of any particular country, fines and penalties are imposed on them. So such fines and penalties are also the income of the government, because you'll pay through the judiciary and what have you, and judiciary is one of the arms of government. So it does generate revenue for them. So to keep operations going. So how do you use government revenue? You could use it in a number of ways. You have development projects. For example, this uh, this mall just after. Sorry, my Wi-Fi is misbehaving, but we'll just move. So I was thinking about that flyover. So you'll find a number of development projects, even the ones that the NMS is doing. Those are some of the projects, that are being done because of the revenue the government has collected. So you have one of the uses I've talked about development projects. This is social welfare services, and then your participation in the production, marketing of commercial goods and services. You have redistribution of income and wealth through taxation and public spending. You have the ability to now run various administration departments established by the government, and then you also have security. Okay. So what's the rationale of taxation? Why taxation? How important or degrading is taxation? Well, There's an aspect of increase in employment. You have I've talked about the increase in employment. I've talked about the allocation of resources. I've talked about the fair distribution of income. I've talked about the social welfare. You have the protection policy. You have economic stability. You have raising of revenue. Social welfare, there is the NSSF. You understand the things that perhaps taxation, if it were up to you, you will perhaps not consider a social welfare scheme. But the government, through income taxation, which we will see later, it does deduct an amount or a percentage of your income, of your net, no, of your gross income, and more or less save it for different aspects of the social welfare schemes. Protection policy, this could be also a health policy. You have NHIF and what have you. So those deductions, okay, really form the basis of the rationale of taxation. So there's what we call the optimal tax systems. So sometimes they're called the OTS. Okay, here there are a number of things. We have simplicity, we have convenience, we have certainty, we have neutrality, we have the administrative efficiency. So just briefly, simplicity means in the optimal rather tax systems, simplicity means understanding and computing. Okay, I don't know if you have ever perhaps those who have NHIF schemes and NSSF schemes, if sometimes wants to log into your portal, they normally send you an SMS. That's an OTS. Okay, so it applies in different spheres. So that OTS, or sometimes it pops up on your notification screen bar. So it pops up and then you're told to enter some digits, and then I know you've seen this before. So the optimal tax systems, I have mentioned those five rather. So simplicity means understanding and computing. Certainty means when and how much, and it is not arbitrary. Okay. Convenience means the method and frequency of payment should be convenient to the taxpayer. For example, the pay as you earn an installment tax. So it has to be proportionate and convenient to the taxpayer. And then you have neutrality, that's self-explanatory. And then you have administrative efficiency. So administrative efficiency talks about that for you to have a good tax system, it should produce the highest possible yield at the lowest possible cost, both to the tax authorities and the taxpayers. Right now, the national tax policy should be for, I think, this financial year should be submitted before Parliament. So I think right now they're still in the process of public participation in what have you to try and get their input. But Kenya actually doesn't have a national tax policy. Or perhaps we do rely on, most of the times, we do rely on just financial bills which form the basis of the acts. For example, the financial bill of 2022 hasn't even been tabled yet at the National Assembly. Okay, because it is the only house that deals with expenditure. Okay, and that includes the budget making process. So I think next month, Ambassador Yatani should be able to table, next month or late this month, should be able to table the budget document before the House. So what has been tabled before from the at the moment from the Treasury, I think, is the medium-term budget. Yeah, and the policy. But the national tax policy, Kenya doesn't have one, and we should be having a national tax policy so that we don't end up, making perhaps laws each at every time, amending, you have the income, tax art, the tax appeals, tribunals, whatever, any law that do affect the tax, regime. so that we either reduce or even amend the VAT Act so that we could reduce the percentage of LPG. LPG is the liquefied processing, liquid processing of liquefied processing of the gas. So the LPG is at 60%. And I was privileged to sit or submit our memorandum on before the Gladys Wanga, the Finance and National Planning Departmental Committee of the National Assembly, on the aspect of reduction of LPG, price. So from 16% of VAT should be reduced to either 8% or 5%, because if you have LPG with a 16% VAT, what it means is, see, people will more or less seek alternative sources of energy, and that will mean deforestation, that will mean charcoal burning and what have you, and charcoal burning and use of charcoal will perhaps lead to more health effects. So again, there's dark through the CO2 intoxication. So it's a whole cycle. Okay, so guys can't afford LPG with a 60% VAT. It's too punitive and extortionist at the moment. So you'd find again, alternative sources of energy would be resorted to, and that will perhaps lead to us not attaining the 10% forest cover that our Katiba has mandated us to have, okay, because of deforestation. So guys want to now use charcoal, okay. Yeah, so we are glad our memorandum was incorporated, and it's in the Hansard reports, of the National Assembly. I will look at it and cite it. It also led now to perhaps the bill, the Petroleum Taxes and Levies Amendment Bill. Okay, again, that was sponsored by Gladys Wanga. Okay, so it seeks to perhaps streamline all the aspects of to streamline rather the taxes in petroleum products. Okay, so the Petroleum Products Taxes and Levies Amendment Bill, I think right now it's in the second reading of the National Assembly. Last time I checked. Yeah, so the National Assembly, both houses are now on a recess until next 22nd of March is the other week. Yeah, so that's when they're supposed to resume, and hopefully the bill would be fast-tracked so that we could cushion Kenyans from the effects of economic genocide. So back to what I was talking about, the optimal tax systems. I've talked about the administrative efficiency. Well, there's also what we call the taxable capacity. So here, the maximum tax, which may be collected from a taxpayer without producing undesirable effects on him or her. And then we have absolute tax capacity is actually measured in relation to the general economic conditions and individual position. For example, the region or industry to which the taxpayer belongs. So if an individual, having regard to his circumstances and the prevailing economic condition, pays more tax than he or she should, then his taxable or her taxable capacity will have been exceeded in the absolute sense. And then we have relative taxable capacity. So I've talked about the absolute taxable capacity, but we also have the relative taxable capacity. So what is RTC, or the relative taxable capacity? So this is measured, by comparing the absolute taxable capacities of different individuals or communities. And then we have equity as the other sphere or aspect of the OTS. So a good tax system, should be based on the ability to pay. So equity is about how the burden of taxation, is actually distributed. So the tax system should be arranged, so as to result in the minimum possible sacrifice. Okay. So equity means, people in similar circumstances should be given similar treatment. So that's what we call horizontal equity, that people in similar circumstances should be given similar treatment. So if it's about the doctors and the lawyers, that is horizontal equity. And then we have the similar treatment. So the similar treatment is the vertical equity now, the inverse. So here, the similar treatment is for people in the similar circumstances. Like you can't expect, an in-house counsel who perhaps or a legal counsel number two at the at the uh, at the Parliament of Kenya who earns say 250,000 shillings as gross income to have the same, to pay the same taxes as a person who works as a casual, either laborer or just let's say a driver, okay, in one of the ministries. So you have that is a dissimilar, treatment. It is it is it is it's what amount to the vertical equity. So you have the horizontal equity and you have vertical equity. Celia will ask you what's horizontal equity, what's vertical equity, how do the two apply, how do the two differ? Yeah, that's it. So the principles that actually may be applied, in the equitable distribution of the tax burden, that's under equity still. So the benefit principle, we have the benefit principle. So here, the tax is actually apportioned, to individuals according to the benefit they deserve from the government activity and spending. And then you have the ability to pay principle. So the ability to pay principle is a distribution of taxes according to the stated taxable capacity of an individual or to some criterion of ability to pay. And then you have the cost of service principle. So the cost of service principle is the cost to the authority of the services rendered to individual taxpayers. So the tax is a payment for which there is no what you call a quid pro quo. You've come across that Latin term, quid pro quo between the tax authority and the taxpayer. So the taxpayer does not necessarily have to receive goods and services equivalent to the tax paid. And you've seen this, okay? If I pay 12,000 shillings, as taxes without even deductions and what have you, that doesn't mean I would receive the same amount of services or goods equivalent to the taxes are paid, okay? Well, canon of productivity. So the doctrine of the canon of productivity means that this canon or this principle proposes that it is better to impose the only taxes that are able to produce larger returns. So as such, it is better to have fewer taxes with large revenues rather than more taxes with lesser amounts of revenue. Okay, so that's self-explanatory. So why would you have, you have a large base of, let's say, 1,000,000 people paying 1,000 shillings of taxes. Okay, whereas you have 500, people paying, say, closer to 200,000 shillings of taxes. So if you compare the two, if you do the math, you would understand that the canon or the doctrine of productivity means you would rather have people or a base, with few people, but with larger revenues. Okay, rather than you have more taxes with lesser amounts of revenue. You get it? So that's the doctrine of canon of productivity. And then we have the canon of elasticity. So the canon of elasticity in the OTS is that the canon proposes that a good tax system should actually comprise taxes that can be adjusted. For example, taxes that can be increased or decreased according to the demand of the revenue. Okay, and then we have the canon of efficiency. So here, taxation should actually produce the right amount of tax at the right time. And then we have the canon of economy. So here, it should incur the least compliance and administrative cost to the taxpayer and authority respectively. So the cost of collection, should be kept at the minimum so that the larger portion is actually retained for government treasury. That's the canon of economy in the optimal tax systems. Then we have the canon of diversity. So what does this mean when it comes to taxes? So the canon of diversity infers that to diversify the tax sources, you have to be more prudent and flexible. So being heavily dependent on a single tax source can be detrimental for the economy. Okay, so if the government said only relied on external borrowing as one of the sources of of their revenue, then it will be it will be fatal. So diversity implies, the canon of diversity implies that it refers basically to diversifying the tax sources, in order to be more prudent and flexible. So if you have the government property and that's what they're relying on for their income, what have you, that shouldn't be the case. So they have to diversify either through parking fees, even the prices, the things I did mention before. So being heavily dependent again on a single tax source, can be fatal for the economy. And then you have the canon of flexibility. So here it means that the income, the entire tax system, should be flexible enough that the taxes can actually easily be increased or lowered in accordance with the government needs. Okay. So now we move to the classification or the grouping or categorization of taxes. So here, taxes are actually classified based on a number of things. And these things are actually three. So you have the impact, you have the tax rates, and you have the tax base. The tax base is what I was telling you about. Okay. You have, fewer taxes but larger, revenue base than, more taxes with fewer revenue base. So impact, it's a classification, based on whom tax is actually imposed, and we call this the tax impact, and who has to bear the burden of the tax incidence. So a tax, has impact on actually the person to whom it is legally imposed, whereas the incidence of a tax is actually on the person who ultimately pays the tax. So whether or not it was legally imposed on him. So key phrases that are important is the tax incidence and the tax impact. And then we move to the other classification of taxes, which is the tax rates. So tax rates may be classified on the basis of the percentage of the tax base to be taken in case of a tax. So in this regard now, the tax may be classified as either progressive, proportional, regressive, or digressive. Okay, and then we now move to the classification of the third classification of taxes. Now that's the tax base. So for the tax base, it may be classified, on the basis of the object upon which the tax is actually levied. Okay, so how do we distinguish now between direct taxes and indirect taxes? Well, a direct tax, is one whose impact and incidence are on the same person. So therefore, a direct tax is one which is paid, and that's what we call the tax incidence, which I talked about, on the impact as one of the classification of taxes. So a direct tax is actually one which is paid, and that's the tax incidence by the person on whom it is legally imposed. That's the tax impact. So for example, you have income tax, you have the corporation tax, you have the wealth tax, you have inheritance tax, and these days they also tax the dead. So that's what we call the death duties. And then we have indirect taxes. So here, indirect taxes, is one whose impact is actually one on, is on one person, but it is paid partly or wholly by another person. Okay, so an indirect tax, can be shifted or passed on, as opposed to a direct tax which cannot. there's that hereditary or inherent aspect of that. And then you have some examples to include commodities such as you have VAT, you have the import and export duties, you have the excise tax, and then you have the entertainment tax. What is a progressive tax and what is proportional tax? Well, progressive taxes, a tax is deemed to be progressive when the marginal rate of the rate of tax, it rises as the taxable income increases, such that the higher the income, the higher the tax rate. That's what we call progressive taxes. So it applies, largely in direct taxation, and that's income tax, estate duty, wealth tax, etc. So if I used to pay 6,000 shillings, as payee, well, if I earn more, that payee will increase. Okay, so that's what we call the progressive taxes. So proportional taxes, a tax is said to be proportional when the same rate of tax is actually applied to all taxpayers. For example, you have the corporation tax, which is always stable at 30% for all firms, regardless. And then VAT again is always standard, 16% on sale of sale price of goods or services. And we have what we call ad valorem duty on imports, the value added duty. Okay, the ad valorem duty on imports. So it largely applies in indirect taxes, or rather in taxing commodities. And then we have regressive tax. What are regressive taxes and how does it differ from digressive taxes? Okay, so regressive taxes, a tax is said to be regressive if the rate of tax falls as the income rises. In other words, a tax is regressive when the burden of the tax falls more heavily on the poor than on the rich, as the poor sacrifice more heavily than the rich. So that's why we say the rate of tax falls as the income rises. And then we have digressive taxes. So what are digressive taxes? So a tax is said to be digressive when the higher income do not make a due contribution, or when the burden imposed on them is actually relatively less. For example, when the tax is progressive and then up to a limit, beyond which the same rate is charged, there may be, relatively lower sacrifice for those who earn large incomes than for the smaller ones. So that's the aspect of the digressive taxes. Okay, so get the difference between the two, the regressive taxes and digressive taxes. And then we have classification of taxes based on the tax base. Okay, well, in this case, the taxes may be classified in a number of ways. One, which forms the basis of our discussion today, is the income tax, where the tax base is the income. Okay, in other words, a tax base means where does KRA derive that tax from? If it's income tax, then the base is income. If it is property tax, the base of the tax base is property. I don't know if you are following that sequence. If it's a VAT now, where the tax base is the sale price of goods or services sold, that is to me now the expenditure. Okay, and then if it's import tax, the tax base is basically the value of the goods imported. If it's export tax, the tax base is the value of goods exported. All right. All right. So perhaps at your own convenience, just to brush through, you can read on the history of taxation, though CND may not bring it, just for your purposes of refreshing your mind. You can read on the sources of government revenue. Again, I have gone through this. Uses of government revenue, What should an optimal taxation look like? I've talked about the OTS, in depth, extensively and intensively. And then you can also now again discuss, a number of case laws which normally, which do analyze a number of canons of taxation. And canons of taxation, there's equity, there's certainty, there's economy. So perhaps you could I don't know if the guys from Kenya Law Africa Publishing, if they're still at Kesal, there are a number of reading materials, that are good for introduction to tax law. There's one by Kitenga G of 2010. Then there was one by, I think, Salemi NA on the principles of law simplified. This is published by the East African Educational Publishers. And then there's also one on economics by Gregory Mankiw and Mark Taylor. So the area of focus is on chapter 8 and 12 of that book. And then there's the book by, I think, Public Finance, by H.S. Rosen and T.J. So the chapters of concern for your studies is chapter 16, 15, and 14. Then you can also check Kenya Law website on the same. So I will now move swiftly to the legal framework and types of taxes. Okay, still within the ambit of what I laid down on the introduction. So my area of focus here will be income tax. Okay, and then I will move to stamp duty tax and finish up with the capital gains tax the next 30 minutes. So income tax is imposed on annual gains or profits earned by individuals, limited companies, business, and other organizations. So long as it brings an income, it adds, your financial base, that's possibly an income tax, an income which needs to be taxed. Okay. So in our country, income tax is regulated by the Income Tax Act, Cap 474 laws. Okay. So what are the sources of income tax? I have told you income tax could be derived from individuals, limited companies, business, and other organizations. Well, the sources of income tax. One, we have the employment income, you have the business income, you have the rental income, you have dividends for a company, you have interest, you have pension and annuity, you have capital gains. Then you have natural, resource income. You have the net gains on the disposal of an interest, which normally derives at a 20% or more of its value, directly or indirectly, from immovable property in Kenya. And then we also have what you call deemed income. Well, what are the income tax heads? The tax heads, they are quite a number. So we have individual income tax, we have corporate tax, we have the pay as you earn, payee, which most of you know. We have withholding tax, sometimes it's written as WHT. You have the digital service tax as DST, which came into force just 2 years ago. You have minimum tax, you have the turnover tax, you have the installment tax, you have the fringe benefit tax or the FBT, you have the residential income tax, for those living in a residential apartments, so the landlord has to remit, that income tax derived from your rent. You have the advance tax, and then you have capital gains tax, which normally is part of the conveyancing stuff. So the charging section. So taxable income, that's under Section 3 of the Income Tax Act. So Section 3(1) of the Income Tax Act, provides that, subject to and in accordance with the Act, a tax to be known as income tax shall be charged for each year of income upon all the income of a person, whether resident or non-resident, which actually did accrue in or was actually derived from Kenya. Okay. So the critical concepts in income tax are as follows. You have the definition of income. What is an income? So the Income Tax Act does not actually define income. It is so silent on the definition of income. So some items of income are actually subject to tax and others are not. So it, however, behooves that in Section 3, subsection 2 of the Income Tax Act, it does list incomes upon which the tax is chargeable. So these include business income, employment income, and passive income, such as dividends, interest, and pension, amongst others. Okay. So the year of income or accounting period is under Section 2, Section 27, and Section 52B of the Income Tax Act. Then you can also look at Section 2 of the Tax Procedures Act. So that those provisions, define what a year of income or accounting period is. So the year of income under Section 2 means that the year of income is a period of 12 months, commencing 1st January and ending on 31st December each year. So it is the same as a calendar year. Okay. So instead of saying, if CLE says income, year of income, don't panic. They just mean a calendar year. Okay. So accounting period under Section 27 again of the Income Tax Act says that the year of income should be distinguished from the accounting year. Okay, so there is a date to which accounts of a business are actually prepared each year, and this date will indicate the accounting year end. So the accounting year ending on 31st December would actually coincide or merge with the year of income. So other accounting year ends will, however, fall in a given year of income, and the profit or even the loss per the accounts will be for that year of income. For example, an accounting date that ended on 30th June 2016 will fall or fail to be treated as the year of income 2016. Okay, so that's the distinction between an accounting year and the year of income. Well, Section 27 of the Income Tax Act does permit a company to record an accounting period other than 1st January to 31st December. However, individuals, and incorporated associations are restricted to the calendar year. That's under Section 27. And then we have what we call a reporting period. So Section 2 of the Tax Procedures Act has introduced a reporting period to mean it's for the purposes of income tax, the year of income, or even accounting period. Okay. And then we have taxable person. So taxable person under Section 2 of both the Tax Procedures Act and even the Income Tax Act says that a person whose income is taxed is either an individual, this is to mean a natural person, or a legal person. This could be a company, a trust, a corporate society, an estate, a club, a trade, association, etc. And then a partnership is actually not taxed on its income. You understand? But the partners are taxed on their share of profit or loss from the partnership. Kindly take note of that. I'll repeat. LLPs are not taxed on its income or any type of partnership, but the partners are actually taxed on their share of profit or loss arising from the partnership. So what are the terms of residence under Section 2? So a resident in relation to an individual means that the individual has a permanent home in Kenya and was present in Kenya for any period during the year of income under consideration, or he has no permanent home in Kenya rather, but was present in Kenya for a period or periods amounting in total to 183 days or even more during the year of income under consideration, or he or she has no permanent home in Kenya whatsoever, but was present in Kenya for any period during the year of income under consideration and in the 2 preceding years of income for periods averaging more than 122 days for the 3 years. You can check at your own convenience the case of Rogers versus IRC. It was an 1879 case. And then you can also check the case of Lowenstein versus DeSalis. Lowenstein is Lowenstein. Lowenstein versus DeSalis. DeSalis is DE space SALIS. That is a 1926 case, okay? Page 42. So a resident in relation to a body of persons means that the body is a company incorporated under the laws of Kenya, or the management and control of the affairs of the body was exercised in Kenya in the way of income under consideration, or it will also mean the body has been declared by the Minister for Finance, who is now the CS of Treasury, Attorney, by a notice in the Gazette to be resident in Kenya for any year of income. That is to mean it was gazetted, okay? A non-resident means any person. This could either be an individual or body of persons not covered by the above conditions that I've talked about for resident. So what is a permanent establishment? Well, a permanent establishment means that a non-resident person with a fixed place of business in Kenya which has existed for a period of 6 months or more, or as determined under the double tax agreement. The double tax agreement is a place called the DTA, where a person wholly or partly carries on business, or a dependent agent of the person, to mean one who acts on behalf of a person and who has and habitually exercises authority to conclude contracts in the name of that particular person. Right? So how do you distinguish between a resident and a non-resident? Well, for a resident, it means an individual person entitled to personal relief. I think currently is at 2,400 shillings per month. And on the other side, for a non-resident, it is an individual person, or that particular individual person is not entitled to that personal relief. On the side of a resident, the corporate tax of resident person is 30%. On the side of a non-resident, the corporate tax of a non-resident person, okay, with permanent establishment is 37.5%, while a person with no permanent establishment is subject to withholding tax or the digital service tax, which I talked about, if applicable in whatever circumstances. And then on the side of a resident, the resident employee is actually subject to tax on worldwide employment income, whereas a non-resident employee is actually subject to tax only on employment income sourced in Kenya. On the side of a resident, the withholding tax is generally an advanced tax. On the side of a non-resident, the withholding tax imposed on a non-resident is a final tax unless they are, they have a permanent establishment. Okay, and then when it comes to a resident who is now a subsidiary and a permanent establishment, in this case a branch, for resident or subsidiary here, the corporate tax of a resident person is still 30%, while on the permanent establishment, a branch, the corporate tax of a resident person still remains 37.5%. And then I've said the resident is subject to tax on worldwide business income. For a permanent establishment, it is subject to tax only on business income sourced in Kenya. And then payments to parent or holding company are tax deductible at arm's length, and this applies to the resident subsidiary. Whereas on a permanent establishment, which is a branch, the payments to parent or holding company are not actually tax deductible. And then on the side of a resident or subsidiary, the payments are subject to withholding tax. On the side of the permanent establishment or a branch, the payments are not subject to withholding tax. So what you have to note in terms of the critical concepts is we have the distinction between a resident and a non-resident, and a distinction between a resident subsidiary and a permanent establishment, which is a branch. Don't confuse the two. So on an income accrued in or derived from Kenya. So here, the income which is taxable is income arising from or even earned in Kenya. So under certain conditions, some business and some employment income derived from outside Kenya is taxable in Kenya. And you can actually refer to section 4 and 5 of the ITA, okay? ITA is Income Tax Act. Then you can also check the cases of ASO. ASO is ASSO Standard Eastern Incorporation versus Commission of Income Tax. This was a 1971 East African case, page 127. And you can also check that famous case of Alfred Granville Rose versus Republic. It's a 1957 East African reports, page 507. On allowable and disallowable deductions, okay? These are section 15 and 16 of the ITA. So the ITA, has listed expenses or deductions allowed against taxable income. And section purposes exclusively. So you have the expenditure wholly and exclusively incurred by the person in the production of that particular income. So these are expenses, okay, which are always charged in the profit and loss account under normal accounting practice, subject to any prohibition or extension made by the Income Tax Act. So again, these are the usual commercial expenses, of a business or even profession. For example, you have wages, rent, purchases, transport, salary, water, etc. And the nature of the business is actually very important, in determining the expenditure which is wholly and exclusively incurred in the production of income. So in addition to section 15.1 of the ITA, allowing expenditure, which is wholly and exclusively incurred in the production of taxable income, section 15, subsection 2, allows specific items of expenditure against the taxable income. Okay. So the question should be, what examples or what are the specific items of expenditure that are allowed? So there are also now expenses or deductions, which are not allowed against taxable income, and these are also listed in the Income Tax Act under section 16. Section 16.1 of the Income Tax Act, generally disallows expenditure which is not incurred in the production of taxable income. So the section reads that for the purpose of more or less ascertaining the total income of the person, no deduction shall be allowed in respect of expenditure, which is not wholly or even exclusively incurred by the person in the production of income. Well, in addition to that provision, generally disallowing expenditure which is not wholly and exclusively incurred in the production of taxable income, section 16, subsection 2 of the ITA, it does disallow specific items of expenditure if charged against taxable income. So at your convenience, you can check the examples of specific items of expenditure again which are disallowed. So what are the sources of income? Section 3.2, give a list of the income upon which tax is chargeable under the ITA as follows. You have business income, employment income, gains or profit, from rights granted to other persons for use or occupation of property, for example, the rent. You have dividends and interest. You have pension. You have charge or annuity and withdrawals from registered pension and provident funds. You have capital gains. You have natural resources income, disposal of an interest deriving 20% or more of its value, directly or indirectly, from immovable property in Kenya. And then you have any other amount, deemed to be the income of any person under this particular act, that is the ITA, or by rules made under the ITA. So when it comes to business 4 of the ITA, well, business is defined in section 2 of the ITA as any trade, profession, or vocation, and every manufacture, adventure, and concern in the nature of trade, and it includes an independent contract for services, but does not include employment. All right. So the profit-seeking motive is prima facie evidence of a trading activity, for any business income. So the motive rather may easily be inferred from the kind of structure or organization in place. Okay. So the profit motive now again may not in itself be conclusive, that it may only be incidental, may be outweighed by other circumstances So there was a case of a Commission of Taxation versus Stone. You've come across this case. It is a 2005 case. It says the court that the High Court, held that the tax a policeman and an athlete was in the business of reward. Money and government grants received constituted income. So the taxpayer was aware that sporting success would actually bring financial gains. So consequently, the taxpayer has, quote unquote, turned the talent to account to money, right? So business income is taxed at the rate of 30% for resident corporate persons. That's the standard price, and percentage rather. And then you have 37.5% for foreign branches. Graduated rates, apply to. Well, on the employment income, you're going to refer to Section 5 of the ITA. So here, the gains or profits, from employment are actually widely defined in that particular provision, Section 5.2 of the ITA, to include wages, salary, leave, pay, sick pay, payment, instead of leave or in lieu of leave, you have fees, commissions, you have gratuity, you have traveling, you have entertainment, or even other allowances. So they also include, employment benefits in the nature of expenditure catered for by the employer, such as the house rent, the motor vehicle, you have the electricity, you have the water, you have the furniture, house help, the telephone bills, school fees, etc. So employment benefits, that are not subject to income tax are actually provided in Section 5, and it does include non-cash benefits not exceeding 36,000 shillings. And that 36,000 shillings is annually. So reimbursement of expenses, expended wholly and exclusively in the production of income, staff meals provided, to employees not exceeding the value of 40,000 shillings per year, and the mortgage deductions, and pensions, contribution relief, or even, specified amounts, among others. Okay. Well, in the types of rather when in employment, individuals are taxed on a while-weight basis, on the income, from employment, and then this means that any employment income paid to resident employee in respect of any employment or services rendered by him in Kenya or outside Kenya is actually taxable in Kenya. So a non-resident is only taxed on employment income in respect of the employment itself, and this could be a Kenyan employee, a permanent establishment. So such employment income is taxable irrespective of the period of employment in Kenya. And you can check a number of cases, and this includes the Securax Agency Kenya Limited versus, the KRA, that is a 2014 Kenyan law reports. You can check the case of UAP Life Assurance Company Limited versus Commissioner of Domestic Taxes. That is a 2019 case. And you can check the case of Equity Bank Kenya Limited versus the Commissioner of Domestic Taxes. That is a 2017 case, tax appeal. Perhaps the last part of my doing before I move to stamp duty tax. There are types of incomes and taxes that you should know, or taxable gains, and that's the individual income tax, the corporate tax, the withholding tax, the payee, the DST, or the digital service tax. You have the minimum tax, turnover tax, installment tax, fringe benefit tax, advance tax, residential rental, income tax, and capital gains tax. Okay, so I will handle those later, so you can just permit me to do stamp duty quickly and then finish up with CGT. So for stamp duty taxes, Section 5 of the Stamp Duty Act, says that every instrument, set out in the schedule to the Act, wherever executed, which relates to property in Kenya, shall be chargeable with the stamp duty specified in the schedule. So the general principle is that all documents or instruments must be stamped unless specifically exempted by the Act. Section 6 of the Stamp Duty Act says that payment must be within 30 days of execution of the document or it's being received in Kenya. Okay. In turn, A of the Stamp Duty Act, provides for referral to government valuer. And then Section 20 provides for the stamping out of time. And then the penalty is 1 shilling in respect of every 20 shillings and of every fractional part of 20 shillings of the duty chargeable in each quarter of the year. What are the effects of non-payment of stamp duty? So evasion, to evade will result in non-recognition and avoidance. Section 19, provides for non-admissibility of unstamped instruments in evidence. And then you can cross-check with Section 46 of the Land Registration Act. Section 113 of the Stamp Duty Act provides for penalty for frauds in relation to stamp duties. So when it comes to amount payable is that prescribed by the Act on the amounts. The aspect of documents, and then when it comes 4% of stamp duty if it is situated within a city, and then you have 2% if it's outside the city or municipality. So the amount pegged is always on the value of the property, and that's under of the Stamp Duty Act. When it comes to leases, it is pegged on the annual rent or averaged annual rent, years or less, and then 2% for. When it comes to mortgages and charges, it is pegged. The stamp duty is always pegged on the amount that is lent at 0.1%, and it is 1,000 shilling. Comes to this. When it comes to those three, the discharges, releases, and reconveyance, it is 0.05% of the amount that has been redeemed. And then when it comes to the nominal duty, it is only certain prescribed documents, and this includes the power of attorney, the assents, the trust deeds, the supplementary security, and you have the partial discharges. So what's the procedure of applying for stamp duty? Well, the applicant presents document for assessment by the collector or even the valuer, and you can check the Ministry of Lands, the rb.go.ke, and then the assessor now confirms if the duty is payable, counterchecks info on the form and document, and then also ascertains amount and endorses both form and document. Then the applicant generates KRA, PIN form on iTax platform, and then the applicant pays amount in desired bank, and then returns the document with proof of payment to collector. So the collector reconciles, the records and stamps documents by franking, and then those documents are audited by the government accountant, and they are dispatched. So that's the procedure. So the reliefs and exemptions under Stamp Duty Act are as follows. You have Section 17 of the Stamp Duty Act, and it talks about the adjudication in collector's discretion. You have Section 106, talks about general ministerial recommendation for relief or to exempt in the interest of the public. You have development partners, research institutions, and agricultural institutions. And then you have Section 117 again of the Stamp Duty Act talks about the general statutory exemptions, and this includes there's also educational institutions. We have family investment companies, and you can check legal notice number 59 of 2007. There is Section 52, subsection 2, which talks about the charitable institution. Section 52, subsection 6 talks about trustees. And then Section 96 of the Stamp Duty Act talks about the subsidiary companies. And we also have other statutes, that work hand in hand with the Stamp Duty Act. And this includes the Central Bank of Kenya Act, you have the Export Processing Zone Act, you have the Shelter Afrique Act, you have the Privileges and Immunities Act, you have the Companies Act, which deals with assurances in now winding up. Okay, and then all this depends entirely on who is actually liable to pay. So what are the consequences of stamp duty in a given set of facts? Is it actually payable? If it's payable, what is the rate? In who pays or is liable to pay? On which document? Is there relief or is it exempt? Clear, calculate the amount inclusive of any penalty. So those are some of the questions that you should perhaps seek to answer. And so the challenges and reforms when it comes to Stamp Duty Act, because CLE may just ask you because they know you aren't taught this, but they know you should know. While stamp duty payment has some challenges, and what are the forms of challenges that are there? What forms of reforms would you propose? So challenges includes the processing itself, okay? And then we also have the connection to capital gains tax, and then the rates payable, especially on transfers. And then you have persons, who are liable to pay or documents, from each according to his means. You have the first-time home owners, you have the mortgaged homes, you have retirees, and then there's the aspect of e-stamping. Will it reduce perhaps corruption and ensure that everything is authentic? Well, um, uh, that's up to you to answer, but that's basically the outline. So what you should read on stamp duty is the Stamp Duty Act itself. You should also read the Land Registration Act of 2012, and you should read the case of Weetabix. Weetabix is just that, Weetabix Limited versus Healthy U 2000 Limited. That is a 2006 case. You should read Republic versus Commissioner of Lands Ex parte Somkin Petroleum Company Limited. That is a miscellaneous application of 2004. You have Fidelity Commercial Bank Limited versus the Agri Tools Limited and three others. That is a 2004 case. So ladies and gentlemen, that's it with the stamp duty. So I would like to give you just a break of say 15 minutes, and then I finish up on capital gains tax. Yeah, so we resume at around, let's say, no, 10 is okay. 12, 1250, yeah. So that I do capital gains tax and I'm done. But see you at 12:15. Hey folks, welcome back. So I just want to read the last and final part of my presentation today for CGT, and then I could cut it off because I'm losing my voice. Okay, I was spoken enough. Well, what we will deal with when it comes to capital gain, as known as CGT, we do the introduction rate of the tax. Who is eligible to pay for CGT? How do we compute CGT and the exemptions and the exclusions? Who is actually exempted from CGT? And then how to pay, and then perhaps on some random engagement or the expectation perhaps, and how do LSK, take up the role when it comes to CGT. So back to introduction of CGT. CGT double taxation. Well, KRA's aim mainly is to uphold the principle of equity and fairness. That's what tax system, which I talked about earlier, as per our. And then it is always the capital profit versus the revenue. So when you look at the Finance Act of 2014, it did introduce the CGT as at 1st January 2015 after the suspension in 1985. Well, CGT is actually declared and paid by the transferor of the property, right? While stamp duty to a purchaser is what CGT is to um, the seller, right, or the transferor. While CGT is actually imposed on whole of gain accruing to a person on transfer property situated in Kenya, whether acquired on or before January 2015. Okay. Well, when it comes to the rate of taxes in CGT, so the rate of tax is always at 5% of the net gain. So that's a final tax. My wife is still misbehaving, but either way. So I've said net gain is sales proceed minus the acquisition and incidental cost. And CGT is on gains arising from the sale of property. So the property is actually defined as land, building. Well, when you look at CGT in comparison with other countries, it is not all capital gains tax. So Uganda charges the rate of 30% applicable on business assets. Tanzania charges, capital gains taxes at corporate tax. While in Kenya, the CGT is the lowest at 5% both in the region or comparative states, but compliance rate is low. So that's what lacks in other in Kenya. Sorry, still Wi-Fi misbehavior. So I've talked about why. What's the compliance? CGT is actually paid by a person who has transferred property, where property is actually sold, exchanged, conveyed, off in any manner of a gift. So on the occasion of the loss of property, also be in place for the abandonment, surrender, cancellation to the property. What are the methods of computing CGT? Well, you have the net gain is the excess of the transfer value over the adjusted cost of the property that has been transferred, and then you have the transfer value is the amount of value of consideration or compensation as incidental cost, and then you have adjusted cost is the cost of acquisition or expenditure for enhancement of value or preservation of the property, defending title, right of a property, and the incidental cost of acquiring. Well, for example, the CGT on land and buildings. Let's assume the transfer value computation. So assume the sale proceed was around 2 million shillings and the incidental cost to say the legal fees was 100,000 shillings, the advertisement was 50,000 shillings, the agent's commission was 200,000 shillings, and the valuation fees was 150,000 shillings. So the sale proceeds is a less incidental cost. So you take the legal fees, the advertisement fees, the agent commission, and the valuation fees. So if you add all of them, it will give you around 500,000 shillings. But remember, the sale proceeds is 2 million shillings. So the transfer value is the valuation is the sale proceeds less incidental cost. So 2 million minus 500 shillings, it will give you 1.5 million. So now when you want to compute CGT, so the adjusted cost computation. So now assume the cost of acquisition or construction was incident. I'm having problems with this Wi-Fi, but either way. So the cost to change the roof of property was 130,000. The legal cost to defend the title was 50,000 shillings. The industrial building deduction, so what we call the IBD, had been allowed to an amount of 450,000 shillings over the years, and this is normally where applicable. So when you want to do the adjusted cost computation, remember what we found out previously, the cost of acquisition or construction is 1.2 million. So when we add all those incidental costs, it will give us around 310,000 shillings. The legal cost 60,000, the valuation cost 70,000, the legal cost to defend the title was 50,000, and then you have the cost to change the roof was 130,000 shillings. So you add those is 310,000 shillings. So this 310,000 shillings, you add it to the cost of acquisition in the previous month that we did. So it will give you around 1,510,000 shillings. So now, when you want to compute the, you have the industrial building deductions that you didn't actually deduct. So that's 450,000 shillings. So you subtract 450,000 shillings from 1.5 million or 1,510,000 shillings. It gives you the adjusted cost to be 1,060,000 shillings. So now you want to compute the gain and the tax thereon. So the transfer value of the land was 1.5 million. So the less adjusted cost after we've done on the math, it gives you 1,060,000 shillings. Now the gain on transfer is 440,000 shillings. So this gain on transfer So 5% of 440,000 shillings gives you a net computation of 22,000 shillings, and that's the capital gains tax. Okay, so the exemptions and exclusions when it comes to CGT is the income that's taxed elsewhere. For example, you have property dealers, of its own shells or debentures. You have the transfer of machinery, including motor vehicles. You have disposal when administering the estate of a deceased. And then you have vesting of property to a liquidator or even a receiver. You have individual residence occupied at least 3 years immediately before the transfer. And then you have the sale of land by individual where the proceed is less than 3 million shillings. So those are the exemptions and exclusions of CGT. Further, we have agricultural land, that is actually less than 50 acres. And then you have the exchange of property during reorganization, restructuring by companies approved by Treasury to be in the public interest. And then the exemption is the transfer of securities by a body expressly exempted under the Income Tax Act. And you have, last but not least, you have the transfer of securities by retirement benefit scheme registered with the commissioner. You also have the transfer of securities traded at NSE, Nairobi Stock Exchange. You have the transfer of property for securing a debt or loan. You also have other exemption as transfer of an asset, between spouses or even the former spouses or the immediate family. You also have property transferred but sold for the purpose of administering the estate of a deceased person, again within a period of 2 years of the death of the deceased of the court decision. So how do you pay CGT? So CGT is always due and payable on or before the date of lodgement of application documents for transfer property at the land office. So the taxpayer is actually required say CGT1, CGT1P, you have CGT2, CGT2P, and CGT3. So that is on exemption for CGT3. So the next step is to access the iTax and generate a payment voucher, PRN, and pay the sum due. So the CGT forms the CGT forms then should be surrendered actually to any nearest KRA office with the attachment of proof of payment. What's the way forward? Sharing information to enhance compliance, dedicated web link to address taxpayer concerns. You also have dedicated backup team, and contact persons as hosted in a KRA website. You have continuous, structured stakeholders engagement, including sector-specific engagement, for example, with LSK. And then you have the CGT guidelines have been hosted on a KRA website. Because CLA may ask you what's the way forward when it comes to CGT? What are the challenges and reforms that you could propose? So what are the expectations of the role of lawyers on CGT? Well, lawyers are actually critical, given their role in conveyance. So they need to advise buyers and sellers on CGT obligation. And then LSK and KRA should also engage or even share information to enhance compliance. And then LSK should actually advise membership, clients, and public of the need for compliance with CGT. This could either be through magazines or forums or those sessions LSK normally holds. And then LSK should be proactive on tax reforms, and this includes proposals for amending tax statutes. Okay, so that basically is all about CGT. So what you have to note is it's on the computation on capital gains, and that's all that matters, together with other relevant information. Right. So yeah, that's it. Well, ladies and gentlemen, that marks the end of my monologue. I've lost my voice, and well, it was for a good cause. So thanks for attending the lecture, and all the best as you keep on oiling the wheel. And yeah, a day at a time. You have to water your garden a drop at a time. Have faith. So if you do have any perhaps concern, just DM me. Right now, my mind is mentally tired. But just DM me. So I've spoken for too long, and I think it's time to now wrap it up. So yeah, that is the session, and I hope you've learned a thing or two. Yeah, so that's it. So all the best in your studies, and looking forward to seeing you soon. Enjoy the rest of your day.
Thank you so much.
Thank you.